Thank you. General Prelogar.
Mr. Chief Justice, and may it please the Court. On January 6, 2021, a violent mob stormed the United States Capitol and disrupted the peaceful transition of power. Many crimes occurred that day, but in plain English, the fundamental wrong committed by many of the rioters, including petitioner, was a deliberate attempt to stop the joint session of Congress from certifying the results of the election. That is, they obstructed Congress's work in that official proceeding. The government accordingly charged petitioner with violating Section 1512(c)(2), an obstruction offense that directly reads onto his conduct. The case as it comes to this court presents a straightforward question of statutory interpretation. Did petitioner obstruct, influence, or impede the joint session of Congress? The answer is equally straightforward. Yes, he obstructed that official proceeding. The terms of the statute unambiguously encompass his conduct. Petitioner doesn't really argue that his actions fall outside the plain meaning of what it is to obstruct. Instead, he asks this court to impose an atextual limit on the actus reus. In his view, because Section 1512(c)(1) covers tampering with documents and other physical evidence, the separate prohibition in Section 1512(c)(2) should be limited to acts of evidence impairment. But that limit has no basis in the text or tools of construction. His reading hinges on the word otherwise, but that word means in a different manner, not in the same manner. And the true prohibitions in Section 1512(c)(2) aren't unified items on a list where you could apply associated words canons. They're separate provisions. They have their own sets of verbs and their own nouns. They each independently prohibit attempts, which would be duplication that makes no sense on petitioner's reading. And Congress included a distinct mental state requirement in C1 that it chose not to repeat in C2. Section 1512(c)(2), by its terms, is not limited to evidence impairment. Instead, it's a classic catch-all. C1 covers specified acts that obstruct an official proceeding, and C2 covers all other acts that obstruct an official proceeding in a different manner. The Court should say so and allow this case to proceed to trial. I welcome the Court's questions.
General, there have been many violent protests that have interfered with proceedings. Has the government applied this provision to other protests in the past, and has this been the government's position throughout the lifespan of the statute?
It has certainly been the government's position since the enactment of 1512(c)(2) that it covers the myriad forms of obstructing an official proceeding and that it's not limited to some kind of evidence impairment gloss.
Have you enforced it in that manner?
We have enforced it in a variety of prosecutions that don't focus on evidence tampering. Now, I can't give you an example of enforcing it in a situation where people have violently stormed a building in order to prevent an official proceeding, a specified one, from occurring with all of the elements like intent to obstruct, knowledge of the proceeding, having the corruptly mens rea, but that's just because I'm not aware of that circumstance ever happening prior to January 6th. But just to give you a flavor of some of the other circumstances where we have prosecuted under this provision, for example, there are situations where we've brought C2 charges because someone tipped off the subject of an investigation to the grand jury's hearings. There was another case where someone tipped off about the identity of an undercover law enforcement officer, and in those situations, there's no specific evidence, no concrete testimony or physical evidence that the conduct is interfering with. Instead, it's more general obstruction of the proceeding. Justice Alito mentioned the Wright case as well, and that's another one where it was a forged court order that prompted the litigant to dismiss a mandamus petition, but that didn't have anything to do with the evidence that was going to be considered in that proceeding.
So what role does C1 play in your analysis?
So we understand 1512(c) to split up the world of obstructive conduct of an official proceeding into the C1 offense and into C2. C1 covers everything it enumerates. It's the acts of altering, concealing, destroying records, documents, or other objects. And then C2 would only pick up conduct that obstructs an official proceeding in a different way. So there's no duplication or superfluity on our reading. Instead, Congress was taking this universe and dividing it up into the two separate offenses. And I think that's actually a virtue of our reading as compared to petitioners, because I have not heard him articulate anything that would fall within C1 that wouldn't also come within C2. So on his reading, C2 really does just swallow C1 whole.
Well, I mean, in the way you're reading it, C2 almost exists in isolation, certainly not affected by C1.
We don't deny at all that there is a relationship between the two provisions, Justice Thomas.
What
but
is that relationship?
And the relationship is the one Congress specified in the text. It's what follows the word otherwise. That is the relevant degree of similarity. What both C1 and C2 have in common is that they or aim at conduct that obstructs an official proceeding. C1 does so in one way, tampering with records and documents. C2 does so with respect to all other conduct that in a different manner does that. And I think that this has to be the road the court goes down, to look at what Congress actually prescribed with respect to similarity. Because in contrast, if you take up petitioner's invitation to come up with some atextual gloss from C1 to port over into C2, I don't understand what the court could look at to guide its determination of exactly what the relevant similarity would be.